for somebody convicted of breaking the international slave trade. So in Article 2, the legislative branch, a very, very important component of our constitutional system, we see slavery implicated not once, but twice. The third place in which we find slavery implicated in our original Constitution is in Article 4, the fugitive slave provision, that the slave owners had a constitutional right to recapture their runaway slaves. And think about that for a moment. Think about people on the run, people wondering around the next corner, is there going to be somebody who's going to drag them back into slavery? And it gets worse, because if you were to look at the newspapers of the antebellum period, which certainly I have done, in a number of newspapers are advertisements for rewards that would be paid upon the capture of a runaway slave. And they're very jarring to read, I have to say, almost like fugitives from justice. So the way in which the law gets written, the structure of the law, will appeal to people's economic self-interest to look for runaway slaves to help the slave catchers bring back these human beings into bondage. So 3 places in our original Constitution, 3 places that are going to cause tremendous political, economic, social, and humanitarian damage. As the antebellum period progresses, this issue of slavery will become front and center. And the rise of the abolitionist movement. This is going to be very, very important in American history. And as you can imagine, there are those who want to do away with slavery completely, but there are also the slave owners in the South who want to use whatever political power they have to keep slavery intact. As hard as the Congress may try to compromise, and they try with the Missouri Compromise of 1820, Compromise of 1850, the Kansas-Nebraska Act of 1854, looking back, I have to shake my head and wonder, how could they think they could compromise on a moral issue like this? Well, ultimately, as the 1850s unfold, storm clouds will gather, and they will break in April of 1861 when the Civil War breaks out. It's leaving to this generation the work that perhaps should have been done initially. But during the Civil War, 700,000 Americans will lose their lives. More than all other U.S. wars put together. That this war will cause so much death, so much destruction. It would be the equivalent of 6 million people in today's population. Well, the Civil War is beyond the 29 minutes I have for this lecture. But in the aftermath of the Civil War, our structure, the structure of our government changes. And it changes with 3 constitutional amendments. In 1865, the 13th Amendment is ratified that abolishes slavery. What a momentous amendment. We'll continue to have prejudice and racism, but slavery will be no more. And now at least we can have a debate about political participation from this former slave community. The 13th Amendment was ratified in December of 1865, and it was followed by two more constitutional amendments, the 14th Amendment in 1868, that brought the idea of the states and the states' rights under federal control much more than it had been before. The 14th Amendment states that no state shall deny any person's life, liberty, or property without the due process of law, and also confirms that we are all entitled to the equal protection of the law. So an amendment is put into our political structure that was designed to correct the problem that was in the initial Constitution that was ratified in the late 1700s. In 1870, the 15th Amendment is passed that prohibits discrimination on voting based on the color of one's skin. Collectively, these three amendments are known as the Civil War Amendments. And if we were to stop right there, we might say, well, good news. You've got the abolition of slavery. The states now are going to be under a stricter federal legal structure, and that people are going to be allowed to vote regardless of the color of their skin. But I think we all know that these issues remained across the post-Civil War South. You had people terrorizing the African American community who were looking to do no more than vote, to have their political voice be heard. That the former Southern political white supremacists begin to rise again. They have the Ku Klux Klan as their enforcement mechanism, and it seems as if not much had changed. Well, eventually, political issues become legal issues, and in 1896, the Supreme Court decides the case of Plessy versus Ferguson. A very important case, even though I think it is a terribly decided case, but nonetheless, it is going to put into our structure a racist caste. Let's look at the case. The state of Louisiana had passed a law providing for separate accommodations on their railroads. Homer Plessy, a person of color, purchases a certain class ticket. He goes to sit in the seat that he had paid for, was told that that car was for white people and that he couldn't sit where he hoped to. He commences a legal action. This action was predicated upon the 14th Amendment. He claimed that the state of Louisiana was denying him the equal protection of the law. After all, he thought his money was as good as anybody else's. The case eventually makes it to the United States Supreme Court, and the Supreme Court rejects Homer Plessy's claim. They state that just because something is separate doesn't necessarily mean it's unequal. Here is where we see the doctrine separate but equal. And as far as the justices are concerned, it's not a close case. It's not one of these 5-4 cases. It's 8-1. 8 United Supreme Court justices thought that it was okay that people have separate accommodations based on the color of their skin. I look back at this case and I really can't believe what I read. But Supreme Court cases matter because the Supreme Court decides these cases, they become precedents, they become embedded in the structure of our government, and anybody who wanted to challenge segregation between 1896 and 1954 had to deal with Plessy versus Ferguson. How do you get around Plessy versus Ferguson? That was the Supreme Court precedent. So think about that. For the better part of one person's life, they're going to live under segregation, and there's not much they can do about it with respect to our courts because our courts had decided the matter. Well, in 1954, things do change. And things change with the landmark case Brown versus the Board of Education. When the Supreme Court looks at public education, they distinguish it from public transportation. And they claim anytime you separate children out in a public school situation based on race, it's inherently unequal. It turns the logic of Plessy on its head. And this was not a close case either. It was a unanimous Supreme Court that decided Brown. And in the wake of Brown, the structure is now going to change. That doesn't mean there's not going to be resistance, but now we have the law